my name is Dan Kaufman, and I'm here on behalf of the MLS network. I'm a board-certified civil trial attorney with over 20 years of experience practicing law and an additional 13 years of practicing as an adjunct professor at a local law school. I'm here tonight to talk to you about a basic overview of how a trial works. And following this, we'll then go into separate installments over each particular part of a trial. Initially, once a case is filed, it takes anywhere from 2, 3, 4 years even to get to trial. During those first 2 years or so, the lawyer spends a ton of time doing discovery, maybe up to 200, 300, 400 hours of time. That time is then condensed into a 3 to 4 to 5 day trial. And each trial is basically run the same way. The jury is brought in, it's called a jury panel, and there's usually 15 to 20 potential jurors brought in. Each lawyer has an opportunity to do what's called a jury selection. That selection process is a very invasive, very private question and answer session. Each lawyer gets the same amount of time, and the judge dictates and controls the questions. Following that, each lawyer for each party then has the same amount of time to give what's called an opening statement. That statement is a roadmap or an introduction to the case, kind of like a movie trailer to a movie before you see it the following weeks, to give you an idea of what the evidence is going to show and what the lawyers think the evidence will show. After that, each party has a chance to call as many witnesses as the judge allows or feels necessary to prove a case or to disprove a case. When the lawyer asks the questions to his or her own witness, that's called a direct exam, and there are rules about that that we'll discuss. After that lawyer is done doing the direct exam, the opposing lawyers for each and every party then have a right to cross-examine, bury, burn, harass to a reasonable extent to get the information you need, undermine everything possible that's reasonably permitted by the judge and within the rules of evidence to then cross-examine that witness so that that witness's testimony loses all credibility or effect. Following the direct and cross of every single witness, the lawyers then have what's called a closing argument, different than an opening statement, and that closing argument is my summation or the practicing lawyer's summation of what they think the evidence has shown, what each witness has said, and what the verdict should be. At the end of that, there is a reading of various jury instructions that the lawyers argue to the court are appropriate. The judge reads that to the jury sent back to a private room where they can stay for days on end, whatever the judge thinks necessary. There's then a knock at the end of that. The verdict is returned and read. And usually somebody's very happy and usually somebody's very sad at that point. We will discuss each and every one of those installments in the weeks to come and look forward to speaking with you then. I'm Dan Kaufman. You're watching Mr. Law School, but you should be studying.